I'm gonna wait a few more minutes to let a few more people join in, and then we'll get started. We'll get started in just a few minutes. All right, let's see. I'm gonna go ahead and get started, and people can continue to join in. I am Jessica Tripp with Campbell and Brannon. I'm in our Gwinnett office, and today we are going to be discussing top 10 title issues, and depending on the time, we may get into some top 10 contract issues as well. If you guys have any questions, just feel free to stop me. I'm more than happy to answer questions. All right, we'll get started. All right, so top 10 title issues that we are going to discuss today. We have divorces, unknown liens, so you can have HOA liens, water liens, federal tax liens, Georgia Department of Revenue liens, or FIFAs, dead people or missing heirs, bad execution of documents, forgeries or false impersonation of a previous owner, prior open security deeds, bankruptcies, outstanding taxes, power of attorneys, and survey issues. So when it comes to divorces, you guys just want to make sure that you are having those conversations with your clients up front. You want to make sure that they are telling you the important things that you would need to know. before taking that listing, and making sure that you ask them, hey, has your divorce been finalized? If they're thinking about filing for divorce, maybe you encourage them to wait until after the closing is over, because if they file during, being under contract, that will postpone your closing. So make sure you are asking the right questions. If the divorce is already pending, that's something that we need to know, because that could potentially delay the closing as well. And if it is pending, sometimes we can still close. It's just going to depend on the title insurance company. Sometimes they will allow us to get something in writing from both attorneys, saying what is to happen with the property and the proceeds. And if we get that, sometimes they will allow us to proceed with closing, but sometimes they won't. So again, that's something that you need to know up front. So if they haven't filed for a divorce and they want to sell the property, they should probably wait. That is your best bet. But if it's already pending, sometimes there are some options to still get it to the closing table. Sometimes we can send all of the proceeds to the divorce attorneys and they can hold it until the divorce is finalized. So there are options there, but you just want to make sure that you're in the loop. If the divorce has been finalized, you want to make sure you are asking them for the correct documents. So you would want to have a copy of the final divorce decree and a copy of the settlement agreement. Do we care about spouses that may not be on title? So let's just say there's just one person on title. Do we care about that? Do we care that there is another spouse out there that was never on title to the property? Could they potentially get proceeds from the sale even though they were never on title to the property? The answer to that question is yes, we do care about them, because Georgia has something called an equitable interest. And so just because that spouse was not entitled to the property, that does not mean that they are not entitled to a portion of the proceeds from the sale. So that's super, super important. So if that settlement agreement states that that spouse is entitled to a portion of the proceeds from the sale, or if it states that we need them to release their interest because they have an equitable interest, so not because they were ever on title, but because they have an equitable interest in the property, we will have to be in touch with that spouse. And that's super important for you guys to know, because if they don't live in the state of Georgia or they're not around, that again could be something that could delay your closing, because we will have to track them down prior to being able to close. All right. All right, so unknown liens. So types of liens that show up on title. So we have HOA liens, we have water liens, we have federal tax liens, Georgia Department of Revenue liens, and FIFAs. So let's dive into those. For HOA liens that show up on our titles, they have a 4-year statute of limitations. So if that HOA does not refile that after 4 years, that lien is expired and we do not have to worry about it. Sometimes if it doesn't get paid in that 4-year period, they will file another judgment, and we'll talk about that, but that will become a FIFA on the property. If there is an HOA lien on title that is not, it hasn't expired, so it's less than 4 years, it does have to be paid at closing. And sometimes the HOAs are slow to provide a payoff, but we do have to have that prior to closing, so just something to be aware of. HOAs do have the right to foreclose if liens go unpaid, so that's something to keep in mind too. It's important that the HOA dues are being paid. Many lenders will refuse to approve a loan for properties that have an HOA with delinquency rates of more than 25%. So that is super important, because it could potentially impact a seller's ability to sell. So if a lender doesn't want to approve the loan because people are not paying HOA dues in that particular subdivision, that will impact a seller's ability to sell their property.
Hey, Jessica.
Yeah.
So I had a client last year that had a big HOA lien. Well, not terribly big, a few $100s.
Yeah.
And I panicked that they weren't going to be able to close, and the seller wasn't inclined to pay it. She had some kind of emotional issue in the situation. So I drove out to the property manager's office, like way out on the edge of town, and paid it
Yeah.
a few weeks before closing. So are you saying I could have just handed them a check at the closing table? And
Well, we could have, or whoever closed it could have showed the payoff on the settlement statement, and it would have came directly from their proceeds. But if the seller didn't want to pay it, you could have done something with your commission agreement that said, hey, you're willing to pay blah, blah, blah for the HOA lien, or reduce your commission by that amount. You see what I'm saying?
yeah, yeah,
Uh,
yeah,
so
yeah,
that's
that would
probably
have been
what
a
I would
little
have done.
messier.
Yeah, to make it a little bit cleaner, I would have just reduced the commission by whatever amount that lien was, so that it's kind of a wash.
Okay, yeah,
Yep.
all right, thanks.
Yeah, absolutely. All right. Water liens. Water liens also have to be paid at closing. As far as water bills are concerned, if the property is located in a county that is lienable, we have to pay any outstanding water bills. So it is specific to the property. Not all counties are lienable. So we take a look at, hey, what county are we dealing with? Is that on the list of counties that will lien if the water bill goes unpaid? If that's a yes, it has to be collected at closing. And so we have to pay any outstanding water bills at closing that are in the seller's name or in the name of a previous owner. If it's a previous owner's name, we will take a look at how old is that bill. Like some counties like DeKalb, 7 years past that bill, no longer, it's expired. But if it's less than 7 years, yeah, we're going to have to pay for that. So it's always important to ask, does your seller have an owner's title insurance policy? Because we can sometimes use that to get that water bill in a previous owner's name insured over if we have the owner's title insurance policy. All right. And then we do not have to collect for water bills that are in a tenant's name. Okay. So just keep that in mind. So if they have a tenant living in the property, the tenant doesn't pay the water bill, and that shows up as an outstanding bill, we do not have to pay that because it will not become a lien on the property. All right. So there's a difference between a previous owner, current owner, and a tenant. So just make sure you know that.
Is Fulton County one of the counties that's lienable?
Yeah, we do collect for Fulton.
Thank you.
Mm-hmm. All right, so federal tax liens. Let me see if I can move this side. Okay, so for federal tax liens, a federal tax lien is the government's legal claim against your property when you neglect or fail to pay a tax debt. The lien protects the government's interest in all of your property, including real estate, personal property, and financial assets. The IRS will file a document which is called a notice of federal tax lien, and that alerts everyone that the government does have a legal right to your property. We do have to pay this at closing. So in order to see if this is actually against our seller, we will ask them for their social security number, and we will confirm if it's a match, because anything remotely similar to your seller's name is going to automatically pull on our title exam. And then we use their social to verify and see, hey, is this our Sally or is this a different Sally? So we will need their social in order to get that. If it is a match, it can take some time to get that payoff from the IRS. So the sooner we get their social, the better, so that we have enough time to actually order and get that payoff back. All right. If it's a federal tax lien showing against the buyer side, we normally do not have to worry about that as far as having to pay it at closing. Will it attach to the property once the buyer purchases the property? 100%. But there's a rule, the purchase money rule in the IRS ruling, that says, hey, if we have a lender involved and they want to make sure that their interest is first, it will be. And so that's all lenders really care about. They want to make sure that their loan is going to be in first position, so that if the buyer doesn't pay them, they have the right to foreclose and they have priority to get funds from that. The federal tax lien's priority would be secondary to the lender. All right. So unless the lender requires us to pay it, we don't have to if it's against the buyer side. Sometimes they still want us to, so we always ask them and see what they want us to do. Okay. So Georgia Department of Revenue lien. So this is also known as a state tax lien or a state tax execution. And it attaches to property which the taxpayer is the owner of record. We also will need the social security number to confirm if it's against our person. And again, we do have to pay it at closing. Same thing with this, it can take some time, so just make sure we get that social ASAP so that we can do our job and make sure everything gets cleared. A FIFA. A FIFA is also another word for a lien. It's good for 7 years and then it expires if it wasn't extended. So they have 7 years, and then if it still hasn't been paid, they have to file an extension on that lien. If they do not file that extension, then it expires and we don't have to worry about it. But if it is against our seller, we do have to pay it from the proceeds at closing. And again, this is something that we need a social security number for to verify if it's against our seller, because anything remotely close to your seller's name is automatically going to show up on title. It doesn't necessarily mean it's against them, but we will not know unless we have the social to verify that. If it happens to not be against them, it's a different person, just a similar name, we will get them to sign what we call an execution affidavit or a not me affidavit, which just basically says, hey, this showed up on our title, but we used your social to verify that this was not you. And you're just saying, hey, I don't know of any liens out there against me, and that I am not this person on this lien. And we get them to sign that at closing.
What is a FIFA?
So it's another word, a fancy word for a lien. So it's very FIFAs. So it's a Latin word, and it's another word for a lien. So let's
would
say
a contractor's lien fall under this?
no, contractor's lien would be like a mechanics or a material man's lien. A FIFA would be, let's say you didn't pay your credit card off. We see those. Most of the time it's credit card companies or some other kind of debt. But the contractors, they typically will use a materials ban lien or a mechanics ban lien.
Oh, okay. Thank you.
Yeah. All right, so deceased owners, if you run into this situation, again, you have to have those tough conversations, or you can push them to us and we're more than happy to discuss with them what they're going to need. But if you do have someone that is deceased, the important thing to check is how did they hold title? And if you need help determining that, again, you can always ask us. We do have that email that is monitored 24/7 by all of our attorneys. And so someone can pull the deed for you so that you can see how the title was held. And that email address is attorneys@cb.law. Again, that's attorneys@cb.law. And again, we're always happy to pull a deed for you so that you can see how the title was held. So again, if you have deceased owners, is it just one person that's on title? Because if they are the sole owner, it is going to have to go through the probate process. And if this has not been completed prior to you going under contract, it could result in a delay of the closing. And so that's important for the buyer side to know, hey, they have not started the probate process yet. This is going to take some time. And so you want to make sure you are setting realistic expectations as to when you guys will be able to close. If there are two people or, 2, 3, 4, whatever, more than one person on title, if you see the joint tenants with rights or survivorship language, then all we're going to need is a death certificate and they are good to go. We will file that with the county so that it's clear, hey, one of these individuals passed away. So our sole owner is now the surviving tenant. If there are multiple owners, but you do not have that joint tenants with rights or survivorship language, it will have to go through the probate process. So again, if that's not done prior to going under contract, you just want to make sure you're setting realistic expectations for when that closing will be able to take place. If it has to go through probate, questions that you need to ask. Was there a will? If so, we, as the closing attorney, we're going to need a copy of both the will and the letters of testamentary. We need the will because we need to check to make sure that there are no specific devices that say, hey, Jessica Tripp is entitled to this particular property. If that kind of language is in the will, then guess what? We've got to have a deed from that particular individual before we can sell the property. We need a deed releasing their interest in the property. And again, if that person doesn't live in the state of Georgia, that can make it tricky or harder. And we just need to factor that in to when we, are going to be able to close. If there isn't a will, then we will just need the letters of administration. You just want to make sure that that is done properly because sometimes certain items are not checked off on the letters of administration. And if that's the case, then you have to go back to the court and get an order from the court allowing the sale of the property. So if you guys ever have a situation where something needs to go through probate, I'm happy to give you guys some referrals for people to assist with that. All right, so missing heirs. All right, so we just kind of talked about this a little bit. If the will makes a specific device to an heir, we have to have that quitclaim deed releasing their interest. And again, depending on where they are, that could result in a delay in the closing. If there is no will, all of the deceased individual's heirs have to consent to appointing an administrator. So what if we have an heir that does not consent to that? That is 100% going to prolong this entire process. So sometimes you have people who are not willing to, consent to things. They're not willing to play along. And so that can complicate things. Notice gets sent to all of the heirs, allowing them time to object. And what if there are unknown heirs? What if we don't know about all of the person's heirs? That again can cause a delay. The court will have to publish notice. It just kind of prolongs the whole process. So these are things to just kind of keep in mind. All right, so bad execution. So if you have a deed or a security deed that's not properly executed and that shows up on our title exam, it can cause issues. In Georgia, you have to have in the presence of language. So a deed has to be signed in the physical presence of an unofficial witness and a notary. So Georgia does not recognize acknowledgement language. So if that in the presence language is not on the deed, we do not have a good deed. And so the title insurance companies will either require that deed be re-executed. And let's think about that. If we have to go back and have a deed re-executed, that could delay things because we got to find those original parties and have them redo a deed. Again, we don't know where people are. What if they're out of the country? Like, it's hard to track down people, especially if this was years ago. So we want to make sure that deeds are being properly executed. If not, it could cause issues. It's another reason for why your client should get an owner's title insurance policy. Ways to correct this. Again, we talked about doing a corrective deed, which is basically just getting those same parties to re-execute the deed and execute it properly. Sometimes there are issues with the legal description where the legal description that was used was not correct, or the name wasn't correct for the grantor or the grantee. And so we can fix that by using what we call a scrivener's affidavit. We can go back to the previous closing attorney and get them to fill out a scrivener's affidavit, which basically just states, hey, we prepared this deed. We made a mistake. We're human. We made a mistake. And this is what it should have said. And then once we file that with the county, most of the time the title insurance companies are okay with that and they will let us proceed with closing. We can also do a notary affidavit. So let's say someone executed a document and they forgot to stamp their notary stamp on there. They signed it, but they forgot their notary stamp. Well, that's a problem. So we could go back to that notary, get them to fill out an affidavit saying, hey, yes, I was the person who actually notarized this document. I just forgot to stamp my stamp. And we can file that with the county. And most of the time that will suffice. But again, being able and having to track down these people can cause a delay. Also, if a security deed does not have that language in the presence of, technically you can say, hey, this security deed is not valid. And that's a huge problem, because if a lender finds out that their interest is not valid because the deed was not executed properly, that is a big, big problem. So it's just important that we make sure that we are using the correct language, because again, Georgia does not recognize acknowledgement language. And what I mean by acknowledgement language is you cannot say, this person came to me and they told me that they executed this document, and so now I am stamping my notary stamp. No, we do not recognize that. They have to physically be in your presence, and then you can notarize it. You can't have someone tell you, yes, this is a document that I signed and now I'm notarizing it. That does not work in Georgia. All right. Okay, forgeries and false impersonations. So believe it or not, we do have people who don't do good things. So sometimes you have documents that have been forged, they get recorded, and they cloud who may be the rightful owner of a property. Another reason for your clients to make sure they are getting owner's title insurance, super, super important. There are cases where someone has falsely impersonated an owner, and what happens in that case. So let's say, you know, someone gets a hold of who the current owner is, they get a fake ID, they're acting like that person, and then they sell the property. Well, if the actual owner purchased an owner's title insurance policy at their closing, they will be in good shape. They could get their property back, no problem. But if they didn't have the owner's title insurance, it would be a little bit trickier trying to go through that process. But these things, whether we like it or not, they do happen. And so again, it's important that you guys are stressing the importance of getting an owner's title insurance policy. All right, prior open security deeds. What happens if we get our title exam back and it shows a security deed on title in the name of a previous owner? What options do we have? Does anybody know? Y'all are gonna make me do all the talking. Okay, so if we get a title exam back and the security deed does show, or the title shows a security deed in the name of a previous owner, if the current seller has a copy of their owner's title insurance policy from when they purchased the property, it is easy peasy. We just send it to the title insurance company and they will insure over it. If they did not get an owner's title insurance policy at closing, it becomes a little bit trickier. We will have to deal with that prior to being able to close, and that will 100% delay your closing, because we will have to go back to that bank. We'll have to say, hey, can you look this up, see if it's been paid. A lot of times it's hard to talk to them because they won't talk to us about someone else's loan without that person's authorization. And you know, if we're not able to track down that previous owner, we're not going to have that authorization. So it can be a long, drawn out process if we do not have an owner's title insurance policy. Another option could be if it was the previous owner. So if it was the person that your seller purchased the property from, we could use the settlement statement from that closing and show the title insurance company, hey, there's a line item on this settlement statement that shows that this security deed was paid off at the prior closing. And we can ask the closing attorney, the previous closing attorney, to provide us with a confirmation, like the wire confirmation showing that they paid that lender off, or the check showing that they paid the lender off. Sometimes the title insurance companies will allow that. But again, the easiest way is if your person has an owner's title insurance policy, we get it insured over and we keep on moving. Sometimes the title exam will come in and it will have a mortgage in the name of your seller, your current seller, but they are saying, I already paid that off. Why is it still showing? Well, sometimes these lenders do not file the cancellations in a timely manner, and so it still shows on our title. We have to still deal with that prior to being able to close. So we're either going to have to get their lender to file the cancellation, or we're going to have to get their lender to send us something in writing saying, hey, that this has a zero balance, and we will file the cancellation. But we would have to have something in writing 100%. We can also sometimes get them to show us their credit report, because a lot of times the credit report will show, hey, this was already paid off, this has a zero balance. So sometimes the title insurance companies will allow us to use that as well. All right. Okay, bankruptcies. So can we close if the seller is currently in bankruptcy? Anybody have an answer for that? Okay. We can close only if we had an order from the court. So most of the time, no. If your seller is currently going through an active bankruptcy, no, we cannot close unless we have an order from the court allowing the sale of the property. What if we have a client who previously filed for bankruptcy? Are we good to go? Most of the time, yes. We would just have to check that that bankruptcy has been either dismissed or the bankruptcy has been discharged. Also, I want to mention with bankruptcies, sometimes people who have filed bankruptcies previously, they will think that that got rid of all of their liens. That is not the case. And so we'll get the title back. There will be liens in the seller's name, and they'll say, oh, well, I filed bankruptcy. All of that was taken care of in the bankruptcy. That is not the case unless there was a specific order filed during the bankruptcy that gave permission to avoid that lien. So unless an order was filed avoiding the lien, then that lien still stands and it has to be paid at closing. So super, super important to make sure you guys are speaking with your clients about that and letting us know as soon as possible if they have had a previous bankruptcy or a current one, because that could cause issues. All right. All right, outstanding taxes. So with outstanding taxes, we must pay any outstanding taxes at closing. Unpaid taxes, obviously, they become a lien. And so again, they have to be paid at closing. Right now, taxes are currently outstanding for 2022. Gwinnett County was due on November 1st. So most of those we are checking, and most of them have been paid. But if they haven't been paid, we still are collecting for those at closing. And then the seller would get a credit from the date of closing through the rest of the year for that. But yes, just make sure you guys are able to tell your clients how those prorations work. I cannot tell you guys how many phone calls we get at this time of the year from previous sellers saying that they got their tax bill in the mail and they don't understand why it still has their name on it since they sold the property. A lot of these counties do not update the name until January 1st. So just, make sure you're reaching out to them. It's always a good touch to reach back out to them and explain, hey, yes, you may get the tax bill, but it was prorated at closing, so you're good to go. You're not responsible for paying it. The buyer will pay it. All right, so power of attorneys. We prefer, even if a power of attorney is being used, that the actual seller or the buyer sign the contract, because we just want to make sure that they are aware that this transaction is happening. And so when you have the power of attorney sign the contract on their behalf, it's not clear that the actual person knows that this is happening. So if we have a power of attorney sign the contract, I always have to reach out to the actual person. So whether that's the seller side or the buyer side, I have to speak to them to make sure that they are aware that their property is being sold or that they are purchasing property, either way. We normally will prepare the power of attorney. So you would have the actual person sign the contract. If they cannot attend closing and they need a power of attorney to sign on their behalf, we will prepare the power of attorney. If your client already has a power of attorney, please send us a copy of that as soon as possible, because we will have to send that to get approved to the title insurance company. And if it's a buyer side POA, the lender also has to approve that power of attorney. And most title insurance companies and most lenders will only approve what we call a specific power of attorney. And that's what we use. A specific power of attorney is specific to the property that's being sold or purchased. So sometimes when your clients already have their own POAs, it's a general POA. And sometimes these title insurance companies or these lenders will not approve of those. So the quicker we know that, the better. If we send a power of attorney to your clients to get executed, it has to be witnessed and notarized. The witness and the notary cannot be the same person, and the witness and the notary cannot be an interested party to the transaction. So let's say there are two buyers on contract and one of the buyers can't attend, so the other buyer is going to sign on that person's behalf. That person cannot be a witness or a notary on the power of attorney. It cannot be someone that is involved in the transaction, okay? Because that's a conflict of interest. Doesn't make sense. But we see people try to do that all the time, and you'll have to re-sign a power of attorney. So just make sure they are following the instructions for that. On the day of closing, if we do have a power of attorney, we will do what we call an alive and well call on the day of closing. So you just want to make sure that your client has a heads up about that, because we will have to speak with them on the day of closing just to make sure that they are alive. We cannot do a transaction or a closing on a property where someone has now passed away. So we have to confirm that they are still alive and that they still want to proceed with the closing. We will also send them an email with the finalized numbers, and we will get them to confirm via email that they approve of those numbers. And that just protects not only us, but it also protects the person that is signing on their behalf, so that they can't come back and later say, I didn't know that those were the numbers. I don't agree to those numbers. So that's just more of a CYA measure. And fraud with power of attorneys. There are issues with fraud. I think I told you guys in a team meeting about recent POA where the notary just stamped their stamp and emailed it to the actual person, and then they signed on top of that. It has to be all original signatures. And so again, it has to be witnessed and notarized in the presence of that person. So you can't say, oh, I know their signature, they're my friend, they sent it to me and I notarized it. No, they have to be in your presence, physically in your presence, for you to witness and notarize it.
Jessica, I'm confused about the first line on your slide that says the actual seller or buyer should sign the contract. I mean, if they were able to sign, they wouldn't need a power of attorney. I don't understand.
So sometimes the actual seller or the buyer signs the contract because they're available at the time the contract is executed, but then they know that, hey, I'm going to be out of town when the closing date comes. And so
yeah. Sorry.
Yeah, no,
I understand now.
Yeah, you're fine.
Thank you.
Yeah, absolutely. All right. So contract issues, and this is the last slide, so we will wrap it up. Common contract issues that we see and that it's important for you guys to be aware of. Make sure you guys are aware of the dates for when things expire in your contract. So make sure you know the contingencies, make sure you know when the due diligence period ends, because not keeping track of that could really result in a not good circumstance for your client. Make sure you're aware of what contingencies you filled out. We have a contract right now where we just got a termination, and the reason for the termination was the appraisal contingency. It did not appraise for the amount. Well, that contract didn't even have an appraisal contingency. So just make sure, you don't want to sound silly. So just make sure you're aware what contingencies are actually there in the contract. Make sure you know the timelines, make sure you know when they expire, especially the financing contingency, because if they can't get a loan in that period, you want to make sure that they terminate the contract prior to that financing contingency expiring, because that could put your client in a bad position where they lose their earnest money. Make sure you're also reaching out to the lender to discuss these timeframes before filling them in, so that they can give you reasonable expectations for when things will be able to happen. And if you need to cushion things, make sure you cushion those things. Make sure you guys know that earnest money is specific to the contract. So if you have earnest money put down on a file and that contract terminates, but that buyer is also going binding on a different contract now, if we have not dispersed the earnest money on the first contract, they will have to put earnest money down on a separate check. Does that make sense? So it's specific to the contract. If you're keeping the file with us and you just want to transfer the earnest money to the next file, we can do that if you send us an email saying, hey, this earnest money is going to be transferred to the new file. Only if everybody is in agreement on the first file that the buyer is to get the earnest money back. So if you have the first file and the buyer and the seller are not in agreement as to who gets that earnest money back, but the buyer is now going under contract on another file, like that could put your person in a sticky situation. Also, make sure you guys are filling out the community association disclosure properly. I talk about this a lot because it comes up a lot. If the seller is not disclosing things properly, they will end up paying for it. So if they don't disclose the initiation fees properly, they will have to pay any differences in that. And they get really upset when they have to pay initiation fees. And so you just want to make sure they are filling that out properly and that you are not filling it out on their behalf. You never want to fill it out for them. They need to fill it out. You can go behind them and check with the HOA to make sure it's accurate, but they are the ones that fill that out. And you just want to make sure you have the conversation. Hey, if you don't fill this out properly, you will have to come out of pocket for it. Make sure if there are any seller allowances for repairs. So let's say there's an HVAC repair that needs to be made and the seller is willing to pay $1,000 to the buyer for that. You have to make sure that the lender will approve of that, because if the lender shoots it down, then we cannot reflect that on the settlement statement. Also, make sure you guys send all amendments and exhibits to not only the lender, but also us. We need that. We got to be able to see that so that we are reflecting the numbers correctly. Always remember that amendments are numbered and exhibits use letters. So it's amendment 1, amendment 2. It's not amendment A. We don't do that. Exhibits, it's exhibit A, exhibit B. You'd be surprised how many people mess that up. Be sure that you guys are checking off all of the exhibits that apply to the contract on page 8, because if you don't check that off right above the special steps, if you do not check that off, technically they are not a part of the contract. So make sure you check all of the exhibits that apply on page 8. And make sure, lastly, that you are signing the contract correctly. We need all owners to sign. So if there are 2 sellers on title, we need both of those sellers to sign the contract. You'd be surprised when we just have one person sign and not both. Everybody that is on title to the property has to sign the contract. If you have an executor of the estate, they do not need to sign the contract in their individual capacity, but rather in their capacity as executor of the estate. So it would be Sally James as executor of the estate of Billy James, okay? They wouldn't just sign Sally James. Same thing if you have an administrator, make sure they sign in their capacity as administrator. Same thing for a trust. They would sign in their capacity as trustee of the trust, okay? Not in their individual capacity. And same thing for a POA. You still have to fill it out correctly. So Jessica Tripp as attorney in fact for Johnny Tripp, you know? It can't just be Jessica Tripp when I don't even own the property. You need to fill it out completely. Same thing for LLCs. You want to sign it in your capacity. So Jessica Tripp as sole member or managing member, but not just Jessica Tripp. Same thing for corporations, Jessica Tripp as CEO or Jessica Tripp as CFO, but not just Jessica Tripp. So just make sure that people are filling the contract out correctly. If you guys ever have questions on how they should fill it out or who all needs to sign the contract, feel free to reach out to us. We're more than happy to assist you guys with that. That is all, unless you guys have any questions. And as always, we are always here to help and support you guys. So if you ever need me, feel free to reach out. And again, we do have that email, attorneys@cb.law, that's always available 24/7. If you need a legal description or you need anything, help drafting a special stipulation, we are here to assist you guys.
Thank you, Jessica.
You're welcome. Y'all have a great day. All right.